Good afternoon, my ladies and my lords. Can I, before I return to my submissions, just pick up on a quick point raised by my Lord Briggs this morning about the effect of the word principle. I was reminded over the course of the adjournment that it's a term of art within Egon Zehnder. Indeed, it's referred to page 152. That's Mr. Justice Mann's judgment. It's a level in the hierarchy below partner and above consultant, to which indeed the respondent was appointed. I'll manage. I'd almost completed the thank you very much. I'd almost completed the textual analysis. Can I just to summarise our position in relation to that? We say that when one, thank you very much, when one takes account of the express use of shareholding at 4.5, and critically the impossibility of holding shares in an activity, sufficient ambiguity is created in terms of the reading of the words interested in. When I say sufficient ambiguity, I mean sufficient ambiguity to avoid compelling the reader or the court to the conclusion that interested in must mean shareholding. There are sufficient linguistic indicia pointing the other way. That's before one gets to the question of the commercial anomaly and before one gets to the question of invalidation. Can I now deal with how this was addressed below? Mr. Justice...
You had 4 points in paragraph 56B. You really pressed 3 of them, and perhaps wisely, you really haven't pressed the difference between the noun and the verb.
I mentioned it en passant, and I'll leave it at that.
Yep, very well.
Mr. Justice Mann addressed the point being raised on behalf of Mrs. Tillman from paragraph 39 onwards, and that's page 161. I say only this about it. Obviously, we support the analysis undertaken by the learned judge. We note that he performed both a textual and a commercial analysis. The analysis runs between paragraphs 39 and 43, and the court will note there was extensive citation from the decision of Mr. Justice Foskett in a case just a few weeks earlier, Tradition Financial Services and Gambaroni, where essentially the same argument was being run. On this occasion, it was Mr. Alkirk, as it happened, who was in my shoes. He had more, his success in that case was more enduring than mine has been so far. That's paragraphs 41 and 42, and at paragraph 43, Mr. Justice Mann reaches his conclusions. And I just draw particular attention at page 163 to the fact that Mr. Justice Mann reaches his conclusions, as one can see from the end of the paragraph, both on normal principles of construction. I'm reading 5 lines up from the end, where he says it would be right to favour a construction which does not give rise to an anomaly, and in addition, it would be right to favour a construction which validates rather than invalidates the clause. Can I now turn to the Court of Appeal? That's page 138. And we have a number of criticisms of the way that the Court of Appeal dealt with the question of construction. First of all, paragraph 12, Lord Justice Longmore refers to the need for there to be a genuine ambiguity before the principle can be invoked. That's the principle of saving the clause, or the validation principle. It may be dancing on a pin to work out what level of ambiguity is required. Our short point is there is genuine ambiguity in this case, as reflected by the textual analysis that we conducted before the adjournment. And I note at this juncture that the Court of Appeal did not engage in the sort of textual analysis that we have just undertaken, notwithstanding that it was performed both in writing and orally at the hearing. The approach taken, on the other hand, by Lord Justice Longmore, giving the only judgment of the court, is perhaps reflected best at paragraph 13. The question is, therefore, what the words interested in mean in clause 13.2.3 of the contract. Lord Justice Longmore continues, I find it impossible to say of a person holding shares in a company that he or she is not interested in the business of the company. Well, we agree. One would say that of a person holding shares in a company, but that is not the right question. The question is, what does interested in mean in this contract, not whether it is always appropriate to describe a shareholder as interested in. But in our submission, the problem gets worse, because Lord Justice Longmore goes on to say, conventionally, those words have that meaning not merely in common parlance and in dictionaries, but also in authority. Now, there are, of course, some species of contract where it is particularly useful to see how words and phrases have been regarded by the courts on previous occasions. But in our submission, that is inapt in the case of covenants in restraint of trade, partly because there's no particular custom and practice that has arisen in relation to any aspects of those sorts of contracts, but also because what an employer is supposed to do, doesn't always happen, I acknowledge, is tailor the contract to the particular requirements of the business and the particular obligations and duties of the employee. It's much less likely in the restraint of trade context that a word or a phrase will continue to bear over a period of time a fixed meaning. What the court went on to do was to refer to 4 cases. I'm not going to look at all of them.
I mean, that's a very nice theory, but one's practical experience is that lawyers tend to reach for, in the old days, an encyclopedia of precedents, and these days their laptops, and find something that's been used before with a reasonable degree of success.
I'm, for the avoidance of doubt, I'm not suggesting for one moment that it was an impermissible exercise. What I am saying is that what's happened in this case is that Lord Justice Longmore has effectively treated what he goes on to describe as the balance of authority as deciding this question. And particularly in the absence of a textual analysis, that in my submission was the wrong way forward. The starting point has to be to interpret the words as they are used in the contract read as a whole. That exercise simply hasn't been undertaken in this case. So I said that I wasn't going to look at all 4 of the cases. I'm going to make a point that's common to all 4 of them. These are the cases referred to at paragraphs 14 to 17. In none of those authorities was it contended that the words interested in or their equivalent did not cover shareholding. The point simply wasn't run. I'm proposing only at this stage to look at the first of the authorities referred to, William Corey and Son against Harrison. That's page 1312, volume 2, tab 25. This is a decision of the House of Lords as to the phrase concerned or meaning of the phrase concerned or interested in. And I only need to refer to the first couple of lines of the speech of the Earl of Halsbury. That's page 1313. Second line, in fact, it would be absolutely impossible, I think, to lay down with precision what is or is not comprehended in such words as interested or concerned in. You must look at the facts of the particular case and look at the business meaning of the words. That is the question to be determined. And we say that's as good now as it was then. It is surprising in our submission that the Court of Appeal failed to refer to those opening words in Corey and Harrison, and instead looked simply at the result in the particular case. In fact, we rely on Corey and Harrison to support our case that the words interested in are sufficiently flexible and wide to avoid having any form of fixed meaning. They are sufficiently flexible and wide to exclude, according to the particular context, the concept of shareholding. Can we turn over the page, please, in the core volume to 140? Having referred to those four cases, paragraph 18, Lord Justice Longmore says, the only case which might be said to run counter to this stream of authority is the decision of Mr. Justice Foskett in Gambaroni. But since the circumstances of that case are arguably different, and it's currently on the way to this court, I would prefer to leave that case on one side and defer to the balance of authority referred to above. I'm just pausing there. By this stage, there were two cases in which it had been contended that the words interested in did not capture shareholding in circumstances where there was a separate express clause in the contract of employment which made precise provision for restrictions on shareholding during the currency of employment. Both of those cases, Gambaroni and Egon Zehnder before Mr. Justice Mann, were decided in favour of the employer. That is the closest authority to the facts of this case in terms of interested in. And Lord Justice Longmore declined to examine Gambaroni despite its closeness to the facts of this case. Of course, each contract is different, it's by far the closest, and does so on the grounds that it was on its way to the Court of Appeal. Gambaroni, for the court's note, is volume 5, tab 75, and that's page 2087. And the relevant paragraphs are 123 to 130 at page 2101. I don't turn them up at this juncture.
Well, has it found its way to the Court of Appeal yet?
No. Lord Justice Sales, as he then was, who was, of course, a member of the court and the Court of Appeal in this case, refused permission. And that's at tab 76, page 2107. You couldn't get a cigarette paper in We Submit between the analysis of Mr. Justice Foskett on the one hand and Mr. Justice Mann on the other, particularly since both relied heavily both on the textual analysis, but more particularly the commercial anomaly that arose. I make these points principally in order to demonstrate that when standing back, we say there is, and looking in particular at the way that the Court of Appeal dealt with it, it is a case where we say there is a sufficient element of ambiguity to engage both conventional canons of construction and the validation principle. And it's notable that the last line of paragraph 18, page 140, what Lord Justice Longmore says is, I would prefer to leave that case on one side and defer to the balance of authority referred to above. Going back to my Lord Briggs' point, of course, it's permissible to look at previous authority, but what we can see at paragraph 18 is the Court of Appeal using previous authority incorrectly, we say, misreading at least the decision in the House of Lords in Corey and Harrison, and failing to engage in textual analysis of the kind that's required. For all those reasons, we submit that the Court of Appeal erred. Well, where does that leave us? If the court is with me that there is a permissible construction, and in my submission, that's all I need to satisfy the court of, that reading this contract as a whole, there is a proper basis for regarding interested in as not capturing shareholding. If the court is with me on that, then application of the validation principle would operate so as to exclude a construction which would lead to the contract being avoided. I propose now to move to our third ground of appeal, and that's, forgive me, I should have dealt with the question of concerned in. Although the Court of Appeal only deal with that under the heading of severance, it's implicit in the way that they address the issue of the words concerned in under the heading of severance, that they regard concerned in also as capturing a shareholding. Of course, in this case, they haven't cited any, I think you might have seen from our printed case that it was not something which figured prominently in terms of, it didn't figure at all in the case before Mr. Justice Mann, and it came in fairly briefly in the Court of Appeal. Can I simply, for the court note, refer to two cases, Ashcourt, Rowan and Hall, which is MS 1508, Volume 3, Tab 37, at paragraph 39, and Adorn, Spar and Amjad, which is Tab 32, MS 1933, 1933, at paragraphs 21 to 23, where there is previous authority, both at High Court level, to the effect that concerned in does not include shareholding. In any event, the bigger picture here, and I don't propose to spend long on this, is that if we are right as to interested in our submission, we must be right in relation to concerned in as well. So I now turn to severance. The respondent says that the law in relation to severance is well settled. That's paragraph 61 of their printed case. On behalf of the appellant, we say that the law is in a state of uncertainty. That since the decision of the Court of Appeal in Atwood and Lamont, there has been a continuing state of confusion about how to apply the test that is developed in it. Further, that in the last 20 or so years, another, better and more readily understandable test has arisen to replace it. In practical terms, and I'm speaking about restraint of trade cases only at this stage, High Court judges dealing with applications for interim relief in relation to restraint of trade in the employment context have routinely been applying the more modern test. And they have been doing so unproblematically. The decision of the Court of Appeal in this case has served, in our submission, to reinstate the confusion that I referred to a little earlier. Of course, I'll go to Atwood and Lamont, and I'll go to the cases that have followed it and the cases that have introduced the new test. But can I deal at this stage, head on, with the suggestion that has been made in the respondent's printed case, paragraph 61, that what we are seeking to do is obtain the court's authority for a test that is, and I quote, significantly easier for an employer to surmount. First, it is not only employers who rely on the doctrine of severance. The cases of Sadler and Marshall, to which I shall shortly refer, demonstrate that it is a doctrine which may be prayed in aid by employees. Second, we do not accept the proposition that it makes it easier for an employer to cut down a covenant. It is a test which better reflects the justice of the situation. We handed up this morning, and I'm sorry that it was left loose on my ladies' and my lords' desks, the decision of a very recent decision called Fresh Asia. Fresh Asia Foods and Loo. The court will see that it's a decision dated 4th of January 2019. It's a decision of Mr. Daniel Alexander QC, sitting as a Deputy High Court Judge in the Chancery Division. And it contains, we submit, a helpful analysis of the state of the law in relation to the issue of severance. But can I particularly draw attention to paragraph 54 on page 13, paragraphs 53 and 54 and 13, I'm sorry. What Mr. Alexander QC did was refer to what he regarded as being a conflict in the authorities, my words, not his, as between the Atwood test and the Beckett test. I'll come back to that in due course. But there are some useful pronouncements about the underlying policy here, which in our submission are quite helpful. Second line down of paragraph 53, one way of doing so, that's to say, looking to the substance, not the form, maybe to recognise that if relatively minor and reasonably isolable surgery can be performed on an otherwise legitimate set of post-termination restrictions, that should be done, and the remainder enforced, regardless of whether it is formally speaking a separate covenant or equivalent to a separate covenant, but in which whether a provision was a separate covenant was treated as a factor in evaluating whether or not the surgery was radical or minor. In contrast, if a great deal of slimming is required for enforceability relative to the restrictions taken as a whole, or the effect is a radical change, that would be regarded as not the sort of contract that the parties entered into and should not be done. Then this, 54, however, whatever approach is adopted, if too strict an approach is taken to severance, rendering unsalvageable all covenants which, internally to a clause or separately, contain one or other stray restrictions, the restriction that goes too far, but which are otherwise reasonable, that may lead courts to find that broader restrictions are valid, so as to avoid providing an ex-employer with no protection. That could have the paradoxical effect of making the position worse for employees, since the power of surgical severance is in part a means by which a court is not forced into a binary decision between all or nothing protection. And I go back to the point I made at the very outset of my submissions about the public interest in maintaining reasonable restraints of trade. A user-friendly and readily understandable doctrine of severance gives effect to the public interest in maintaining in that aspect of restraint of trade, say the public interest in enabling employers to protect their legitimate business interests. The test which is effectively pressed upon the court by the respondents is one which history and, in our submission, logical analysis shows to be extremely difficult to apply. Without any further ado, can I now go to the case of Atwood and Lamont in the Court of Appeal? We can put Fresh Asia to one side. Atwood and Lamont is page 788. That is tab 2 of volume 1.
I was just looking up whether isolable was actually a word, but apparently it is.
And it permits of
It's
only
a synonym of isolatable.
and permits of only one meaning. The Atwood and Lamont is at page 788. This was a second-tier appeal. The case concerned a business which operated, as one can see from the first line of the headnote, Draper, Taylor and General Outfitter. The defendant was employed as a tailor cutter in the business and was subject to a 10-mile area non-competition covenant whose critical element is found halfway down the page. That is to say, either on his own account or that of any wife as his or in partnership with or as assistant servant or agent to, carry on or be in any way directly or indirectly concerned in any of the following trades or businesses. And then the businesses are enumerated: tailor, dressmaker, general draper, milliner, hatter, haberdasher, gentleman's, ladies' or children's outfitter, so on. Taken together, the plaintiff's business comprised each of those individual activities, but the overall business was as a draper, tailor, and general outfitter. The defendant, as I say, was only employed as a tailor. The question for the court was whether or not that clause, which was admittedly too wide to be enforceable, was nonetheless severable so that the restrictions could be cut down, leaving just the tailor. At first instance, severance was held to be unavailable. The matter was then appealed to the divisional court, and the appeal was upheld. Severance was permitted. There was a further appeal by the defendant, and that appeal was upheld in the Court of Appeal, the decision we are now going to look at. That's simply to give the sort of the chronology of the litigation in that case. The first judgment was given by Lord Sterndale, and it starts at page 794. The relevant part on 794 is at the very bottom of the page. I think, therefore, that it is still the law that a contract can be severed if the severed parts are independent of one another and can be severed without the severance affecting the meaning of the part remaining. And then to page 795, if you would, please. The test that he had just expressed is then explained as by saying, we can see from the top line, by saying that the severance can be effected when the part severed can be removed by running a blue pencil through it. This is a figurative way of expressing the principle. He prefers the statement of principle of Mr. Justice Sargent in Navanas and Walker. I do not think that those remarks, referring to Mason and Providence, were intended to be applicable to cases where the two parts of a covenant are expressed in such a way as to amount to a clear severance by the parties themselves and as to be substantially equivalent to two separate covenants. It remains, therefore, to consider whether the covenant in this agreement can be considered as though it contained a number of several covenants, each relating to a separate trade. I think it clear that if the severance of a part of the agreement gives it a meaning and object different in kind, not only in extent, the different parts of it cannot be said to be independent. And then turning to his conclusion on the facts, this is page 797. Starting at the top of the page, Lord Sterndale is referring to the evidence in that case that each department within the plaintiff's business was conducted in a sealed way. In other words, employees in Department A were not supposed to have any contact with customers of employees from Department B. And then 5 lines down, Lord Sterndale picks this up. If this be the true meaning of the agreement, it was, as it is described, an agreement not to trade in opposition and not an agreement to restrain the unfair use of secrets or knowledge of customers acquired by the servant in the employer's service. To effect this object, the retention of the restraint to the business of all the departments is necessary. And I think that to strike out all but the tailoring department is not merely to remove one of several covenants, each directed to the legitimate object of preventing unfair competition, but to alter entirely the scope and intention of the agreement. So it appears that Lord Sterndale is suggesting that this was not a case of several covenants in one, and therefore couldn't be severed. Lord Justice Atkin at 797 agrees with Lord Justice Younger. Lord Justice Younger's speech also begins at 797, and it is this speech which has become, as the Court of Appeal later described it in Beckett, as the starting point for the law of severance. And the relevant passage is quite a long one, at page 810. It's the paragraph beginning, "Now I agree with the Master of the Rolls," and the following paragraph. I shan't read them out. I invite the court to read them, please. A number of points we make about this passage. As I say, this passage has become terribly important in the development of the law of severance. It is important, we think, to note that the extent of the covenant appears to have been determined by both Lord Sterndale and by Lord Justice Younger, not simply as a matter of construction, but on the basis of the evidence of what the plaintiff's business actually was. And we can see that halfway down on page 8110. The respondent is, on the evidence, not carrying on several businesses but one business, and in my opinion this covenant must stand or fall in its unaltered form. But the more pressing observation that we make is this: there does not seem to be, in our submission, any good reason why it was held to be a single covenant rather than distinct promises not to work as a haberdasher, draper, tailor, etc. As a matter of construction, there would be no difficulty at all if one turns back to the clause itself, either as expressed in the headnote or in the report of the report at page 789, why the prohibitions against working as a tailor, dressmaker, and so on, could not have been expressed as separate and individual promises. It is, we suggest, a real problem when one looks at Atwood, that although the test is expressed as one of identifying several distinct promises, the application of that test on the facts of the case is problematic. This has been pointed out from a distance by Mr. Justice Coomaraswamy in the Humming Flowers case, the case which we cited in our printed case, and which we will find in page 1332.
Mr. Laddie, I've got a minor question about Atwood and Lamont. When you read Lord Justice Atkins saying rather carefully, "I agree with Lord Justice Younger," you say to yourself, well, obviously he's not agreeing with Lord Sterndale. Is there a difference between Lord Sterndale and Lord Justice Younger?
On our reading, it's not a very significant one. It is that... That's the short answer. That's the short answer to your question. We don't see a particularly significant difference between them. Insofar as there is a difference, we would say this: Lord Justice Younger expresses the test of the importance of single versus multiple promises more distinctly than does Lord Sterndale. But that may just be...
Very well. Thank you. Yes, the Singapore case.
Yes. It's tab 26 of volume 2, and it's page 1332. This is we pray and aid the analysis in this case, maybe because the analysis of severance is performed from a distance. Mr. Justice Coomaraswamy was dealing with an appeal from a decision on a restraint of trade. is able to offer criticism that the Court of Appeal, subsequent to Atwood and Lamont, has felt constrained against doing. And one will see at 1332, just above paragraph 128, the heading, Two Difficulties with Atwood. I'm not proposing to look at the first difficulty, although we agree with the observations. Much more important is the difficulty identified at 129. The second difficulty with the approach in Atwood is that the question of divisibility of promises is artificial and instrumental. It is also fundamentally circular. It amounts to saying no more than that a contractual promise can be severed if it is severable. One need only look at the result in Atwood itself for an illustration of the artificiality. The divisional court took the view that the string of prohibited trade set out in the restrictive covenant was in substance several divisible obligations permitting the severance of one without affecting the remainder. The Court of Appeal took the opposing view and held the entire covenant to be void. Now, we have been doing a little bit of detective work as to what may have happened in Atwood, and this is not within our printed case, this is subsequent to it, in an attempt to understand why it was that the divisional court and the Court of Appeal in Atwood reached different decisions, or to look at it slightly differently, why it was that the Court of Appeal in Atwood did not find that the covenant consisted of a number of distinct promises. And the answer may lie in the way that argument flowed in the divisional court. The second authority that we put up loose, again, apologies for that, on the bench is Atwood and Lamont in the divisional court. It's, I'm sure I'm going to distort the pronunciation. The divisional court consisted of Mr. Justice Bailacci and
Bailish.
Bailey, thank you, and Mr. Justice Sankey. Could we please go to argument on page 151? Argument was developed.
What page of the bundle is that? I've got it.
It's
in email.
forgive me. It's not
Well,
a bundle. It's loose. Sorry,
Well, actually, you very kindly sent it by paginated email.
did we?
Well, it's a Adobe type document. Don't worry, I'll find it. Page.
It's internal page 151.
Thank you.
We've got a spare hard copy, my lord.
No, I'm very happy looking at it here.
He's very unhappy looking at it.
I haven't looked at paper for a year.
He's not allowed to.
Yes, I'm there.
Okay. It was argued on behalf of the defendant, on just about 6 lines from the bottom of the page. There is no case in which a covenant restraining a servant from rendering assistance to another person has been severed. And then Mr. Justice Bellick says this: there is no difference in principle whether the doctrine of severance is applied to area, subject matter, class of customers, or to the kind of work open to the servant. And we underline, or to the kind of work open to the servant. It appears that in response, counsel for the defendant referred to a judgment of Mr. Justice Younger, as he then was, in Great Western and Metropolitan dairies, to suggest otherwise, that kind of work open to the servant was some precluded category of restriction. In other words, one that fell outside the severance principle. That appears to be the way the argument was proceeding. However, when one turns to the judgments and in particular, top of page 155. One can see as follows: covenants of this kind are severable, and the severance can be effected by striking out restrictions which are excessive with respect to area or subject matter or classes of customers, provided any such restriction is so expressed that it can be dealt with as a separate negative obligation. So perhaps conspicuous by its omission at that stage is reference to kinds of work that may be performed. However, further down the same page, the judgment goes on to say as follows: this covenant is, in my opinion, severable by limiting its operation to the trade or business of a tailor. It would then, I think, be unobjectionable. And we read that as this court, that's to say the divisional court, treating the business, the trade or business of a tailor as an instance of subject matter. In other words, merging subject matter and capacity. Now, the plot thickens a little bit when one comes to the first instance of a decision relied upon by my learned friends of the Court of Appeal apparently applying distinct promises test. And that's the case of British Reinforced Concrete and Shelf. That is a decision found at tab 4, page 830. So I did say Court of Appeal. I think it's correct to say it's High Court, although the judgment is that of Lord Justice Younger. And it's important to note that the Shelf decision post-dates Atwood and Lamont in the Court of Appeal. The clause in issue is at page 832. It was a non-competition clause in relation to reinforced road reinforcement. The clause is towards the bottom of page 832, and one will see by clause 3. So for a term certain, there's a vendor and purchaser case, I should add, the firm shall not, nor shall any member of the firm, either alone or jointly, etc., either directly or indirectly, carry on or manage, or be concerned or interested in, and then this, or act as servant of any person concerned or interested in the business of the manufacture or sale of road reinforcements in any part of the United Kingdom. And whilst the clause is in front of us, can I perhaps say this? The phrase, or act as servant of any person concerned or interested in, ... was what was ultimately held to render this clause void. It was wider than was necessary to protect the legitimate business interests of the plaintiff. It was also held, it was part of the main purport of the clause and could not be severed. We'll have a look at that in a second. But Lord Justice Younger did hold that the words the manufacture or could be severed at the very end of the clause. And the reason for that was that the defendant had never been involved in manufacture, but the plaintiff had.
Well, the reason why it could be severed, or the reason why, if it was removed, the clause would be unobjectionable?
Sorry, I didn't catch that.
Was that the reason why it could be severed, or the reason why, if it was severed, the clause would be unobjectionable?
It was. I think it's right to say it was opposite, because ultimately the clause as a whole was rendered void,
Right.
because of the prohibition on entering the employment of somebody who might hold shares in a competing company. So you could go into a completely non-competing area, yet find himself in breach of the covenant. And that's what was held to be too wide and not severable. Yeah, the business which had been sold, to answer my Lord's question more precisely, the business which had been sold had never been engaged in manufacture.
But the point is that the objectionable bit of it couldn't be severed.
Yeah, but what I'm looking here at
It doesn't really matter what might just possibly have been severed.
Yes, there was a pleading point taken on the question of severance, because counsel for the plaintiff tried at quite a late stage to introduce a severance point, and one can see from page 839 that Lord Justice Younger generously declined to decide the case on a mere point of pleading. And he goes on to consider whether severance is permissible at all. He says, in some respects, the covenant is too wide to be supported. It is admittedly too wide in scope in the respect I have just mentioned. That is a reference to the servant clause. If the legitimate purpose of the covenant is the protection of the business sold as distinct from the purchaser's other business, it is too wide in area. It is also admittedly too wide in scope in that it extends to the manufacture of road reinforcements as well as their sale. The Loop firm never at any time manufactured reinforcements. Now, in this last respect, the covenant can, I think, quite properly be severed. So what's happening in practice is that Lord Justice Younger is saying, you can't, the covenant is good insofar as it prohibits you from working as a seller of road reinforcements, but it is bad insofar as it prohibits you from acting as a manufacturer of road reinforcements, but the latter can be severed. He says this is a severance in respect of the subject matter of the restriction, which is fully justified by the authorities, but to cut out the servant clause from the agreement is another matter altogether. And then, strangely, he cites not Atwood and Lamont in the Court of Appeal, which had already been decided by that stage, but Atwood and Lamont in the Divisional Court. All the cases on this subject were cited at the Divisional Court in Atwood and Lamont. And there's a citation of the passage that we've already looked at. We are struggling to understand why it is that Lord Justice Younger in Shelf is relying on the judgment of the Divisional Court in Atwood and Lamont when he was a member of the Court of Appeal that overruled it.
Isn't he reading somebody else's judgment?
Yes. Sorry?
He's not just reading out a judgment, somebody else delivered his
Oh, yes, sorry. So you're reading out Mr. Justice Asprey's.
Why?
Oh, sorry, what was it, cross purposes? No one can see from the note of argument that it was Lord Justice Younger. One can see it at page 836, for example.
Yes.
And there's no sign of Mr. Justice Asprey. Mr. Justice Asprey remained on the bench, I think, until 1929. I'm speculating. It may be that the case had originally been listed in front of him, and he was ill, and so Lord Justice Younger stepped in.
I see.
I don't know.
So we proceed on the basis it is Lord Justice Younger speaking for himself.
Yes.
Very well.
I'm afraid our researchers couldn't turn anything up other than that. I think it's just
Very well.
Now, it may just be that this is an oddity, but what emerges, we submit from this, is the hint of an idea that Lord Justice Younger drew a distinction between the severability of area, subject matter, and classes of customer on the one hand, and capacity in which one works on the other. It's not entirely satisfactory, even on Lord Justice Younger's own terms, because it is arguably the case that in Shelf, by agreeing to sever manufacture or, it is truly a question of capacity rather than subject matter. But there's a bigger point in relation to all of this. There is no good reason of principle why distinction should be drawn between any of these different elements. Either it's possible to sever, having a look at the individual contract, or it isn't. What is special about capacity, or to use the words seen in the divisional courts in Atwood and Lamont, kinds of work available? What is special about that particular concept which brings it out of the ordinary rules in relation to severance? We say nothing. We say that insofar as it's a doctrine at all, it is one which is incoherent and unjustifiable. Now, my learned friends cite a number of cases. My learned friends cite a number of cases in which they say the several promises test has been applied. I'm not sure that it would be a fruitful use of our time to go through those. We suggest it might be better to move to the more recent development of the law, the development of a test which, as we indicated earlier, is user-friendly and more likely to result in a just outcome for reasons that we will shortly explain. The first of those cases is the case of Sadler. That's page 1264, volume 2, tab 20, my lord. So this is an example of an employee relying on the severance doctrine. The employee had entered into an agreement with the employer governing the payment of commission post-termination of employment. One of the conditions for entitlement to that commission was his compliance with a restrictive covenant. The plaintiff, who was the employee, admitted that he breached the covenant. The question was whether the covenant was void in restraint of trade, and the effect, if it was. It was the plaintiff who contended that the covenant could be severed, thus entitling him to retain his commission. And he was successful in the event before Mr. P.J. Crawford QC, sitting as a judge, Deputy High Court judge. The relevant analysis of severance is at 1267, going over to 1268. A number of authorities are referred to, particularly at paragraph 17. Halfway down paragraph 17, the court will see a reference to T. Lucas and Co. and Mitchell. It's an authority we've referred to in our printed case and is within the core bundle. The reason I highlight that is that it's said by my learned friends that there is no reference to Atwood in Sadler. True, no express reference to Atwood, but Atwood is referred to at length in Lucas and Mitchell, and it can be assumed that Mr. P.J. Crawford QC had it well in mind. In any event, the net effect of this judgment is the innovation, we say, of the three-stage test that arises or occurs at paragraph 19. Having referred to a recent Court of Appeal competition case, he concludes as follows: in my judgment, the combined effect of those authorities is that a contract which contains an unenforceable provision nevertheless remains effective after the removal or severance of that provision if the following conditions are satisfied. 1, the unenforceable provision is capable of being removed without the necessity of adding to or modifying the wording of what remains. 2, the remaining terms continue to be supported by adequate consideration. And 3, the removal of the unenforceable provision does not so change the character of the contract that it becomes not the sort of contract the parties entered into at all. So the first of those tests is the strict blue pencil test. Is it possible, whilst retaining grammatical sense, to strike through one or more of the words in the provision, or the whole provision itself? It is a necessary but not sufficient condition. Second, the need for adequate consideration. And third, a broader brush question of whether the severance would change the character of the contract. Now, we know that in our learned friends printed case, they adopt this as the current test. They say that this is the test which currently applies. But they also say that this is consonant with the test developed in Atwood, and that part 3 of this test should be regarded as encompassing the divisibility of promises test that was developed in Atwood. And we say that is unsustainable. Paragraph 3, or bullet point 3 in this test, we'll have a look at in a second about whether it's the extent to which it's been adopted in the Court of Appeal, but bullet point 3 contains nothing about severability of promises. This marks a departure from the need to identify whether promises are in truth severable or not. The Sadler test...
Do you mean severable or separate?
Sorry, separate. Although, for the reasons expressed in Humming Flowers, there's no difference between those. It's circular. But my Lord's right, it is separate. The next authority is Marshall and NM Financial Management, a case which on its facts is quite similar to Sadler, in that it is the severance doctrine being prayed in aid by an employee rather than an employer. It was a decision of Lord Sumption when he was sitting as a Deputy High Court judge back in 1995. The page reference is 1025, and it's tab 12, volume 1. And the relevant passage is at 1030, the first part. At B, on page 1030, the judge holds that the principles on which unlawful provisions of an agreement may be severed from the rest of the terms are reasonably clear, and cites and follows Sadler. He explains why it's appropriate to follow that test at D, the first 5 lines at D. And then critically this: it is altogether more satisfactory than the more traditional and question-begging statement of the test, whether there is one obligation or more than one. And we'll just pause there. We agree. Trying to work out, in the light of the facts of Atwood in the Court of Appeal, what is and is not a distinct promise, is too difficult and elusive an exercise. Lord Sumption went on to add, or to suggest potentially the addition of a 4th condition, namely that the severance must be consistent with the public policy underlying the avoidance of the offending part. So, just by way of potential example, if it was clear that a covenant had been worded in extremely wide terms, but using language which made it also clear that these were separate promises, it may be that the court would say, using condition number 4, that this was objectionable as far as the underlying policy was concerned, and therefore severance should not be tolerated. But it doesn't arise for discussion in this case. So we've got two decisions.
This assumption had said that the principal modern authority for even the third proposition was the Kemidus case. Now, it's in our bundles. You've not referred to it. That was Court of Appeal. Is that because you have doubts about whether the Kemidus case can be regarded as the principal authority for the third proposition?
Yes, I think that's a fair question, and I can only answer it straight. Yes, it's difficult to extract from Kemidus the full force of the test that assumption adopted. For reasons that sorry, I beg your pardon.
It doesn't look as if in Sadler it would have made any difference whether part of a comprehensive non-restraint of trade set of provisions was severed, or the whole lot. Because
Sadler or
no, I'm still on Sadler, but I think you say the facts of this one are very similar. We haven't looked at them in detail. But my question is, am I right in thinking that it wouldn't have made any difference in Sadler whether just one bit of a restraint of trade clause was severed, or the whole restraint of clause was severed because you couldn't sever a bit of it?
Yeah, I think I don't think it makes any difference at all.
Right. So that the particular problem with which we're concerned, namely severance within rather than of a restraint of trade set of provisions, didn't arise.
Didn't arise in those cases.
Did it arise in Marshall?
No, it didn't. It didn't arise in Marshall either. However, just going back, Shelf, which we looked at a little earlier, involved an acknowledgement that the words, my Lord will recall, manufacture or might be severed.
Yes, oh yes.
And we submit that is a good illustration of the point that there is often severance within a restrictive covenant. And what we'll do is, by looking at Beckett, which is the next case, we'll show that that's been repeated subsequently by the Court of Appeal. So Beckett is page 816, volume 1, tab 3. This was a case where a 12-month non-dealing clause was held unenforceable at first instance and not severable too, and that decision was reversed on appeal. It's a relatively recent decision, 2007.
Both bits of it, or
I'm sorry?
which were both the unenforceability and the not severable? That's all one thing, is it? Or were there two separate things that needed to be overturned by the Court of Appeal?
No, it was held to be unenforceable. The question in the Court of Appeal was whether or not it was severable. So, although enforceability was argued, it was argued unsuccessfully. So we turned to the court. We ended up in a position where the Court of Appeal was simply considering the question of severance.
But of the whole restraints, or just one of them?
I'm sorry, I didn't catch
But
that.
of the whole restraint regime, or just part of it?
The whole restraint.
Right.
But as we shall see, what the bit that gets severed is only, if that is an answer to my Lord's question, is only a part of it. Sorry, I misunderstood my Lord's question. It's only in fact, it's part of a part of the definition of relevant client.
Well, the trouble is we're trying to understand what you were saying without reference to what the case was about, and that's always difficult.
It's a 12-month non-dealing clause. All non-dealing clauses, of course, well, good ones, have definitions of who the client is, who the individual is prohibited from dealing with. And the issue in this case was that there was an extended definition of relevant client, which meant that individuals who had been agents or employees of the plaintiff's clients could not be dealt with in an individual capacity by the defendant employee after he left employment. So if he, for example, gives advice to Smith and Jones Company via their representative, Mr. Thomas, the non-dealing clause prohibited from dealing with the company, but also prevented him from dealing in a personal financial capacity with Mr. Thomas subsequently. And that was held to be too wide. That's all falls within the definition, and the question is, could that be severed? For current purposes, that's the question, could it be severed? The discussion of severance starts at page 827. And for my lady's note, the clause itself, or rather the extended definition to which I referred, is shown at paragraph 30 on page 826. At 32, we've got Lord Justice Maurice Kay agreeing that the extended definition was too wide. And then at paragraph 33 on 827, the final controversy on this appeal is as to whether the extended definition, being at least in part unreasonable, is severable from the primary definition. I'm going to take this case quite slowly, if I may. Paragraph 34, he explains the historical assumption that courts should be reluctant to sever in favour of an employer in a restraint of trade case. The roots of that assumption came from Lord Moulton in Mason. But then at paragraph 35, to the extent that Lord Moulton was suggesting that there is a special rule referable to employment contracts, his observation has not found favour in the more recent authorities. See, for example, Lucas and Mitchell. It's in our printed case, it's in the core bundle. I haven't referred to it because it's not a particular dispute in this case. Like the judge in the present case, I find the appropriate starting point to be Atwood and Lamont. And there's reference then to Lord Sterndale, paragraphs 35 and 36, and Lord Justice Younger at 37. Paragraph 38, although strictly obiter, these statements have always loomed large in any consideration of severance. There is only one aspect of Atwood and Lamont which has been authoritatively rejected. We're not sure what significance to attach the word only there. That was the suggestion that in employment cases, even where the prerequisite for severance is established, the court may nevertheless decline to order it. That's the Lucas point to which I referred. As Lord Justice Maurice Kay read the later judgment of the Court of Appeal, that's to say Lucas, it expressly adopted the thrust of Atwood and Lamont, but rejected the discretionary element. So far, so good. That's up to paragraph 39. And then paragraph 40, there's reference in the Court of Appeal for the first time to the Sadler test. And the reference to the fact that in a number of recent first instance decisions, a threefold test has been applied. And the court may well remember that in our printed case, we have set out illustrations of a number of decisions, first instance decisions, where the threefold test has been applied. There's an explanation of where it comes from, and addressing the employees' counsel's argument that the Sadler test, the Sadler-Marshall test, was either an aberrant extension of Atwood and Lamont or an application of within a subset only. Paragraph 42, in my judgment, these more recent cases are neither aberrant nor merely applicable within a subset. In Lucas, Lord Justice Russell referred to the necessary approach based on Atwood and Lamont as being a matter of construction, including the question whether one obligation can be removed or severed without altering the nature of the contract and without having to add or to modify the wording otherwise than by excision. I see no difference in principle between those words of Lord Justice Russell and the third stage of the threefold test in Sadler. It seems to me that the threefold test there formulated is a useful way of approaching these cases and should be adopted. Now, it is right to say that the Court of Appeal, having regard to the spectre of Atwood and Lamont looming large over the development of the history of the development of severance, does not move away, does not formally distance itself from Atwood and Lamont. But by inviting or requiring subsequent courts to apply the three-stage test in Sadler, in reality, what was happening was a departure from the Atwood test. That is the way that first instance courts have continued to treat it. In Fresh Asia, that of course the authority, Mr. Alexander, QC, which I referred to much earlier, this is page 10, paragraph 41, having engaged in an analysis of Beckett, Mr. Alexander says this: the implication from the Court of Appeal in Beckett was that the historical reluctance to sever was something of a relic, notwithstanding the fact that it was authority from the House of Lords and had been subsequently adopted by the Court of Appeal. The Court of Appeal in Beckett, in its language, the test it approved, and its reference to authority, were implicitly rejecting an unduly technical or narrow approach to the question of severability, and did not focus on whether the provision should be severed fell as a matter of form into a completely separate subclause. So one can see that what emerges from Beckett in both the approval of the Sadler test and the application of that test to the words in dispute before it, did not look at the question of whether or not we were dealing with a situation involving separate promises. Separate promises has no role in the Sadler test. We would go further than that. By omitting severance of the definition, of part of a definition clause, it cannot have been the case that the Court of Appeal was interested in whether or not it was dealing with separate promises. I turn now to this case and start with the clause. If the court's against us on grounds 2 and ground 1, then the only question that's left is whether or not the words interested in, and I suppose potentially concerned in, are severable. On any view, whether one applies the Atwood test or the Sadler test, the words may be excised by the use of a blue pencil without affecting the grammatical meaning of what remains. In other words, what is left remains grammatically whole and sensible. There is no dispute, but there is consideration. The question is whether on either test, the Sadler test or the Atwood and Lamont test, we are dealing with separate promises. Now, our submission to the court is that it is an appropriate opportunity, given the confusion that has reigned in relation to Atwood and Lamont, given to the obvious elusiveness of establishing whether or not a promise is in truth distinct or not. It is time to do away with Atwood and to adopt Sadler. But let's assume that I'm wrong in relation to that. Could it be said that the promises in our covenant are separate? And we say, obviously they are. You answer that by asking whether or not it is possible to rewrite clause 13.2.3 on page 188 as a series of separate promises. It would be laborious and cumbersome, but it could be done. Indeed,
Is that an answer to the question? If it's a question of substance or form, it ought not, in principle, to depend upon whether you stick it in one paragraph or 20.
well, we agree. We absolutely...
But why does the fact that you could stick it into 20 paragraphs therefore answer the question in your favour?
Because it demonstrates the artificiality of the exercise. How does one... What is the test that one applies to establish whether or not this is a separate promise? Ultimately, you have to ask, could it be expressed as a separate promise? So to look at this case, and indeed, my Lord, I think it was implicit in some of the questions that my Lord asked me this morning in relation to ground one. Treat the prohibition against shareholding as a discrete prohibition. Well, could it be done as a matter of construction of clause 13.2.3? Yes. One could extract from clause 13.2.3 the words that were held to encompass shareholding and express them as a separate covenant. What else, we ask rhetorically, could it mean? But even this debate demonstrates how difficult this test is, how elusive the answer is, and why it is better, we say, to apply the Sadler test. The Sadler test allows the court to step back, to assess the restriction as a whole, and to ask whether or not the deletion that is being sought is a deletion which is in accordance with justice and doesn't transform the character of the agreement that has been entered into. It isn't a test that is either easier or harder, but it is one which is more likely to meet the justice of the situation. Can I briefly deal with the way that the Court of Appeal in our case addressed this issue? It's page 141. First of all, Lord Justice Longmore holds that the argument in relation to severance is unappealing because the clause would still be too wide. This is the concerned in point. And if we're right in relation to interested in, then in our submission we're right in relation to concerned in. The thrust of clause 13.2.3 is to prevent Mrs. Tillman from working at a competitor. See the introductory words at 13.2. To the extent that there is also a prohibition, a limited prohibition on shareholding, it doesn't form part of the central thrust of this restraint. So we say from a position of justice, that is a good indicator that severance ought to be permitted. The second reason that Lord Justice Longmore alights on for not allowing severance is found at paragraphs 29 onwards. He says, it is well settled that parts of a single covenant cannot be severed. This raises directly the problem of identifying what a single covenant means, The examples that we've cited in our printed case, plus we say Shelf, plus Beckett, show that he's simply wrong that parts of a single covenant cannot be severed. Individual words are frequently severed. They must be parts of, at the very least, parts of a single covenant. It is a requirement, holds Lord Justice Longmore, of severance, that it can only take place where there are distinct covenants, as for example in clause 13.2, which enumerates separate covenants, and then this, perhaps not even then. And that in our submission must be wrong. That would seem to suggest that even looking at clause 13.2 as a whole, all of the covenants, no element of severance would be permitted. The whole thing is one large promise. It is, with respect, difficult to follow the reasoning there. And it may well be that Lord Justice Longmore is confusing, or conflating, I should say, forgive me, conflating sub-paragraphs with covenants or with promises. But what is the reason for holding that the Atwood and Lamont test does not apply here? It's this. It's the last line of paragraph 29. Clause 13.2.3 is a single covenant preventing Miss Tillman from engaging or being concerned in a competing business in any one of several capacities, has to be read as a whole and cannot be severed. That is the effect of Atwood and Lamont, where severance was refused in relation to specified trades. And so we can see that what appears to be happening here is because in Atwood and Lamont there was a refusal to treat draper, hat milliner, tailor as separate promises, the capacity point, that same refusal is continuing into this case because the prohibition at 13.2.3 bites in an objectionable respect on a particular capacity, that is shareholding.
Well, 13.2.3 would have to be severed in totality, wouldn't it?
No.
Well, what can you remove from it?
From 13.2.3?
Yeah.
Assuming that interested in means shareholder.
Well, it means shareholding among other things, doesn't it?
Well,
potentially at least.
Yes. Well, it's we say it means active interest, but all we say needs to be severed at 13.2.3 at page 188 are the words or interested. Take out the words or interested, what remains is grammatically whole, does not affect the thrust of the clause. Clause is aimed at preventing working in a competitor. It is not the business of Egon Zehnder to hold shares. And with respect, my lord, we disagree with the suggestion that the one would have to excise the whole of 13.2.3 in order to achieve justice, in order to comply with either the Atwood and Lamont test or the Sadler test. It's actually, if one goes back to Fresh Asia, the court may recall paragraph 53, Mr. Alexander QC referring to minor isolable surgery. This is a paradigm example of it. A relatively small element of deletion which allows the thrust of the clause to remain in place means that the court can avoid the unfortunate binary result of an all or nothing approach. It is precisely this kind of situation for which severance is most appropriate.
Can you just help me with one problem I have?
My lord, I'm a bit hard of hearing.
Can you help me with this problem? Assuming that we are having to compare the clause as it is, including the bit you want to sever, and the clause as it would be if you take the severed bit out.
Yeah.
Do you construe the clause as it would be if you take the severed bit out as if it had never been there, or do you, as it were, keep a shadow of it there to remind yourself what the words which remain actually mean? Can I say why that's a problem?
Yes.
One might well think that concerned didn't include ownership of shares in a clause which then goes on to say, or interested.
Oh, I see.
So if you get rid of interested, it may have the effect, if you treat interested as never having been there, as widening the meaning of concerned. But the problem doesn't stop there, because if you get rid of interested and concerned, you might ask whether shareholding might be an aspect of being engaged if the parties simply used that single word. Now, my question for you is, how do you actually approach, because you're doing a sort of hypothetical construction exercise, that problem?
If you are deleting, severing, words interested or interested, then, and doing so in order to avoid this covenant being held unenforceable because of what would otherwise be an unreasonable restriction on shareholding, that becomes part of the matrix of fact when one comes to construe what's left.
Well, in other words, to borrow my Lord's words, does the shadow of interested in remain?
As in order to negative what is left. Yes. The way I put it was it remains part of the matrix of fact. In other words, one would approach construction of what remains in the light of the knowledge that one had severed out something which is objectionable because it covered shareholding.
What if interested in is only objectionable insofar as it refers to one thing, i.e. shareholding, but not objectionable in respect of other things that people might do?
Yep.
Can you sever something that is partially objectionable and partially not objectionable?
Yes. That's our short answer to it. Yes.
Well, how? Wouldn't that fail the blue pencil test? Because the blue pencil test requires you to be able to remove a word or not remove a word, rather than carve a single word up and replace it with one of two words which together encapsulate its whole meaning.
If that was the case, severance would rarely, if ever, be available, because it would always be possible to find some alternative valid element of the words that were sought to be excised, which would be unobjectionable. Now, the position in this case is, interesting.
Well, we may be at cross purposes. Yes.
Oh, sorry.
If what you mean is yes, because even if it has something unobjectionable, even if the word interested has something unobjectionable, if you sever it, you lose that too.
Yes.
Then I understand.
Sorry, yes.
Yes.
Yes, that is.
We were at cross purposes.
That's what I understand.
You lose everything that comes within the embrace of interested.
Yeah.
Absolutely. And if the consequence of that, judged against the background of the entire clause, is so fundamental as to change the character of what's left, then severance is impermissible. But we say that's not the case here, for the reasons I expressed earlier.
Well, especially if you want the severance.
Well, we're suggesting contextual interpretation in all of our grounds.
Mr. Laddie, in paragraph 29, Lord Justice Longmore is relying heavily on chitty, paragraph 16.215. You've given us a chitty, it's 27, it's MS 1350 or something like that, but you've given us the new chitty. And 16.215, I think, is a reference to an earlier chitty.
It is.
So, do we, in fairness to Lord Justice Longmore, do we need to see that? Or can we see that if you tell us that it's precisely the same as what is now numbered as ...
Can I check that? I'm not going to pretend I've
Very well.
a photographic memory of whether there have been any changes in the...
Well, it would be very wise for you to check it and get back to us on that, particularly as you're now a minute out of time.
Yep.
We haven't got the equivalent.
I apologise for taking a little...
No, that's not your fault. We've been badgering you with questions at the end of your time.
Well, it's been a pleasure to,
That's my
to
fault.
endeavour
Sorry.
to answer them. Unless I can assist further, my lady, those are our submissions.
Thank you very much indeed, Mr. Laddie. Mr. Solomon?
No more.
Sorry.
Thank you, my lady.
So, my lady, in terms of the structure of my submissions, two parts really. First, this afternoon I'm going to deal very shortly with the policy that we say draws together the three strands of this appeal. And then, secondly, I will deal with the 6 propositions which we say provide the roadmap and the answer to this appeal. Very shortly then, policy. We say this: over the last century, the courts have struck a careful balance between freedom of contract and the protection of employees. And I accept, I should say at the outset, that a balance falls to be struck. And experienced judges have put in place rigorous safeguards to regulate the imbalance between what is often different bargaining positions of the employer and the employee.
But are you saying that different principles apply in the 2 classic contexts in which restraint of trade applies, that is, a vendor and purchaser of businesses, and employment contracts? Have we not got to think at all times how whatever we're being obliged to think or urged to think will apply in the other context?
I accept, yes, at all times one has to look at both contexts. I certainly accept that. It's very easy to get into
one's head, yes, employers are in strong positions, employees are comparatively weak positions, but that balance is not necessarily the same as between vendor and purchaser of businesses.
That's right, I certainly accept that, my lady. And that's why one sees, and I'll perhaps come on to this when I get to the detail of my submissions, but one sometimes sees, just to take Lord Sumption's 4th limb of policy, that the court says, yes, but I stand back, even having considered, for example, the question of severance, and say, is it consistent, is what I'm doing consistent with the policy in this area? And I would be the first to accept that some of the doctrines that we're looking at here, be it saving the document or be it severance, are doctrines that are applied outside the prism of employment law. I certainly accept that.
Is severance applied outside restraint of trade? I was thinking of illegality.
Well, illegality was what I had in mind. Beyond severance and illegality, it's perhaps difficult to think of examples, but perhaps I'll reflect on that overnight, if I may.
Thank you.
What I certainly did have in mind, though, is one sees it applied through slightly different policy eyes in, for example, potentially patent cases, as one sees saving the document applied. And as my lord will know from the Warner case, which we refer to, the courts have looked at this, as I say, in slightly different contexts. But perhaps, as I say, I might develop those more nuanced points as I come to them in my submissions. So we say fairly rigorous safeguards have been put in place. And as we develop, we say the restraint of trade doctrine itself is applied flexibly. The court does not use ingenuity of construction to save extravagant restraints, nor does the court start to carve up a clause in order to extract a reasonable covenant from the unreasonable one the employer has chosen, unless, and this is the key, there are in truth separate obligations. And I should say now, I accept that that is a question of form and not substance. Forgive me, it's a question of substance and not form, as the question from my Lord Briggs indicated earlier. And in this appeal, we say that Egon Zehnder effectively seeks to undermine those important and long-standing safeguards, and that the approach that it invites does run contrary to the policy of the law in this area for the last 100 years, and we say it is contrary to settled principle. And we make 4 points about the underlying policy which has moulded the law. The first point we make in the employment context in particular is that employment contracts will often contain what might be described as boilerplate restrictive covenants. That is to say, covenants drafted by the employer, rarely negotiated by the employees, often signed without legal advice. There is often an obvious imbalance in the bargaining position. It's the employer's document. The second point we make under the policy head is that when an employee wishes to take up new employment, that imbalance plays out in 2 further important respects. First of those respects is that if the covenant is cast in broad terms on its face, and I'm going to use the language of authorities, if I may, prohibiting any part or lot of a competitor, barring all access, the sort of clause we see here, the employee may assume that she simply cannot do any of the things that the covenant ostensibly prohibits. In the words of the authorities, the employer ends up bluffing the employee. The second part of this imbalance and the way it plays out is if, in fact, the employee seeks to challenge the scope or enforceability of the covenant. And as this court knows well, what we then have are the employer seeking an injunction from the court, and injunctive proceedings are, in colloquial terms, not for the faint-hearted. They require very deep pockets.
Defending them is not for the faint-hearted, or bringing them?
Well, with respect, I would accept both sides of that, but in that an employer who brings them may well think that there's considerable risk with it. But for the employee, the risk may be very much more real. I mean, one only has to look at the cost of the interim hearing in this case.
But the hearts in question are quite often those of the former and later employer, with the employee being a sort of pawn between the two.
Well, my lord, I certainly accept, and certainly in many of the cases that I appear in, that that's often the case, because if the employee is a pawn, as it were, as my lord puts it, between two
And I don't mean to pawn pejoratively at all, but,
No.
but not incurring the economic risk.
No, and my lord, I accept it. One can think of cases inter-dealer brokers, bankers and the like. But my lord...
Well, you live in much more exalted circles than I did when I was a first instance judge. The restraint of trade case that I most remember is a hairdresser.
Well, and if I may, with respect, my lady, adopt that. The point I was coming to is that, in fact, if you look at the majority of these cases, they're not about the bankers who are moving from firm to firm and are well represented. They are very often about hairdressers. We've got, I think, beauty salon cases here. And, if I may respectfully use the term, quite ordinary forms of employment with employees who may only be earning £30,000 a year or perhaps less. Employees who couldn't risk costs orders of hundreds of thousands of pounds. And my lady will have seen, we make reference to effectively the Litigants in Persons Guide for the Queen's Bench Division. I mean, the first thing that appears there is applications for injunctive relief in relation to employees. So you'll have people who aren't represented. And indeed, if we look at the historic cases, the court will have noted that cases like Mason involved a pauper. And it's not, in fact, the only case to have reached the highest court in the land which involved a pauper. So there's a whole spectrum, if I may respectfully submit, from Lord Briggs, my Lord Briggs's pawn case, right the way down to the hairdresser case. And I would respectfully submit, without giving evidence, that the majority of the cases are probably towards the middle or bottom end rather than at that top end. And even when it may be said the employee is something of a pawn, there may still be issues for the employee who may still have to pick up the costs of it all. So we say what one needs when one has that in mind is a rigorous rule. What one wants is certainty. What one doesn't want is uncertainty, because uncertainty will always suit the party with deeper pockets. And again, just pausing if I may, although I have pressed the interim costs in this case, of course, the way in which these cases play out is you have your interim hearing and then you have your speedy trial. And the cost of the speedy trial will very often be far more than the interim hearing. And so, quite typically, there was no trial and take this case, for example, there was no trial because we went to the Court of Appeal on a point of law. But had we not got permission to appeal, this case would have gone off for a speedy trial. So one has to bear in mind that there is a very real, to use the words of Lord Moulton, a genuine and potential terror in the expense of litigation. Those words resonate, we would respectfully say, today. The third point I make, and I've probably trespassed on it in answer to the questions, is that the more uncertain the outcome of the litigation, the less rigorous the rules, the more the odds are stacked in favour of the party with deeper pockets. So, if there is a prospect of the court rewriting a covenant that is not clear, or using its ingenuity to save a bad covenant, or, if I may say, having heard my learned friend's submissions, abandoning the rigorous and robust test of are there separate obligations, and replacing it simply with the touchstone of would it be just to cross out parts of this clause, one can see immediately that it will be problematic for at least some employees. And then the fourth point we make, under the heading of policy, is that the law does not, and we say should not, encourage employers to draft extravagant clauses. And we make, I hope, the simple point that requiring an employer to draft an enforceable clause is not unreasonable. And this is a case in point. We will look at them if necessary when we come to it, but we've set out for the court the model clauses in this area, which contain a carve-out for a small shareholding. One can quite simply, if one wants an enforceable clause, which refers to an interest, pick up any number of practitioners' books and copy one out with a carve-out, perfectly enforceable.
And that's as true in 2003 as it is in 2019, is it?
Well, we say yes, and we anticipated the question. We've given you employee competition, which doesn't go back to 2004, which I think is when this contract was entered into. We've also
December 03, I think.
December 03, you're right, my lord. We've given you also, though, and we've given you camelling on competition. We haven't given you the fourth edition of that book, but we can provide it. The fourth edition of camelling is 2004, so at about this time.
Okay.
And that provides a model clause in the same form, namely the carve-out for shareholders.
What's the book?
It's camelling on restrictive covenants and competition, I think. Can I perhaps just give you a copy tomorrow?
Have we not got it in the...
It's in the authorities just bear with me, my lord.
Well, Mr. Woodcock, I don't want you to waste time. Come back to it tomorrow morning.
I'll tell you now, the camelling is at tab 31 of volume 2 of the authorities bundle, which is page number 1385.
But you've given us the sixth edition.
Exactly, just so you can identify the text. This is the sixth edition. What I will furnish you with, if I may, tomorrow is the fourth edition.
Thank you very much.
Is it accepted on your side that the interested in and or concerned in provision would have been valid if it had been followed by the same carve-out as in clause 5?
Yes.
4.5.
4.5. In other words, is the objection just to the failure to carve out a 5% holding, or to the inclusion of any shareholder?
We say, I perhaps don't go so far as to say that the 4.5 carve-out is perfect, not having it directly in front of me, but in principle, if I may answer my lord's question, in principle, we say simply that it needed a carve-out of that type, which you see in the model clauses. And we say that in part for two reasons. Because the model clauses, in fact, make 2 points. First, that you need the carve-out, because absent the carve-out, you are trying to do something that goes beyond what is necessary. But the second thing that the model clauses show, with respect, is that interested in is used to catch a shareholding. The reason you have the carve-out is precisely because the words interested in catch a shareholding. And I would accept, before the point's raised, of course, that one does get into the slightly circular question as to whether the carve-out means that you infer that it's caught. But broadly, we say the model clauses are very much in line with the thrust of our argument. So we say, in very short terms, that in this appeal, policy and orthodoxy coincide. We do not ask this court to change the law. We say that the law is clear and is as stated in the Atwood line of authorities. We say that policy provides no support for a loosening of principle. On the contrary, the manufactured arguments that are put forward to avoid the consequences of a badly drafted clause here point the other way, and we say policy points, as I say, the other way. So that's really all I had by way of opening. Can I come then to the detail of the argument and my second section? And as I say, we've got 6 propositions. What we've done on 1.5 sheets of paper is just reduce the propositions themselves to writing. If I perhaps hand those up to save your pens, and I'll run through them.
Thank you.
And I hope I can take the first point quite shortly. Our first proposition concerns restraint of trade and really the application of restraint of trade. And we say that it is a mistake to try and limit, crystallise or fetter the restraint of trade doctrine by defining trade as limited to livelihood or similar, as the appellant invites. We say the doctrine is to be applied to factual situations with a broad and flexible rule of reason, and it applies to the non-compete clause in this case. Indeed, we say the non-compete clause is an example of the most common application of the doctrine, i.e. a post-termination restraint imposed on an employee under her employment contract. And perhaps I can begin by respectfully adopting what my Lady Hale said is a thread that runs through the appellant's arguments on this. We say that the appellant confuses in this appeal the question of whether or not the restraint of trade doctrine applies with the question of reasonableness. And we say that the paradigm example of a case where the restraint of trade doctrine will apply is a non-compete clause. It's actually difficult to think of a better example of a case where you would have thought the court starting point is the restraint of trade doctrine applies, the employer or the vendor and the buyer in a slightly different context have then to justify the restraint. And so in the employment context, we say there really is no difficulty. We make 4 points. First, and I'm not going to go back to ESSO, but we say what is perfectly clear from the House of Lords decision in ESSO is that the doctrine isn't limited or fettered, and indeed that it is a mistake to try and so fetter it. And that's because if one tries to fetter it, it runs the risk of stultifying the law. Even within the employment sphere, employment contracts have changed over the last 20, 30 years. To give an example, it's not uncommon now for employees to be given shares, or perhaps phantom shares, or some other interest. Indeed, it's not uncommon now to take the pawn-type case, or the higher end of employment, if I can put it like that, for employers to insist on an employee having some skin in the game in terms of some sort of ownership interest. So one of the reasons why we say it would be a mistake to try and fetter this doctrine is because it is part of a doctrine which traditionally has been used and extended where appropriate to new factual situations, new contracts. The Solus agreements in the 50s and 60s at the end of petrol rationing are really just an example of an economic development and the common law flexibly adopting and grappling with it.
But there must be boundaries to the doctrine. Would you like to define them for us?
Well, with respect, my Lord, I wouldn't presume to do so in circumstances where the House of Lords has said it's a mistake to define the boundaries. For the purposes of this case, I would respectfully say I don't need to go further than this. This court is concerned with a post-termination restraint in an employment contract. And there are two obvious reasons why that is, as the cases show, a paradigm case. First, because employment contracts very often are not moulded by competition. I won't say they are never moulded by competition, that would obviously be wrong, but the majority of employment contracts are not moulded by competition. The second point is that a non-compete clause is almost by nature of its character designed to restrain trade. And in fact, this clause, we'll look at it in due course, but we do say it's very, very broadly drafted in that it begins by saying you must not indirectly or directly, and then it gives a list of principal manager, etc. And then it says directly or directly be engaged, concerned, or interested in. So you have a very broad provision. And one of the oddities, and it's a real tension in my friend's submission, and we'll see it when we look at the Marshall case tomorrow, is that if you look at the way the cases work, they ask, is this clause or is this contract in restraint of trade? Is this non-compete in restraint of trade? They don't say the clause is in restraint of trade, but actually we look at some aspect of it and we carve that out from the doctrine of restraint of trade. It's almost some separate severance argument that my friend is running. What one would do is one would say this is a post-termination restraint. On its face, it prevents someone being concerned, engaged, interested in. That's governed by the restraint of trade. Is it justified? What one doesn't do, we would say with the greatest of respect, is say, oh, but can we take interested in out of that and say, well, that bit of it isn't governed by restraint of trade? That's a slightly long answer. I apologise, my Lord, but I hope it goes some way forward. So that's the first point that we make under this head. The second point we make is that restrictions on shareholdings engage the core concerns of restraint of trade. By way of diversion, my lords will have seen, and my lady will have seen, in our printed case, we referred to the Dutch Golden Age, and we gave an example of both wealthy merchants and deckhands having ownership interests. And what's said in relation to that is that those ownership interests, both of the deckhands with their small interests and the wealthy merchants, were part of the boom, the economic development of that culture at that time. And if one comes forward some 300 or so years, again, shares are at the heart of a modern economy. So we say that the notion that interested in catches a shareholding, but that it is not a restraint of trade, is really a rather impossible one. It's a commercially unreal one. The third point that we make under the restraint of trade doctrine is that we say, and this really comes back to a point I made before in answer to my Lord Wilson's question, when you have one integral clause, which is what we're concerned with here, and that integral clause is governed by the restraint of trade, one doesn't, as I said before, try and split out a part of it and say that part is not so governed. And we will see that even when we look at the Marshall case, which my learned friend relies on. And then the fourth and final point I make under this head is we say that the appellant's test on restraint of trade is completely unworkable. How does the court assess at an interim hearing whether the restraint affects a person's livelihood? What is the value of a 1% or a 10% interest in a startup? This court will know that many startups don't actually pay out any money at all to start with, but one hopes that it's going to become a unicorn or whatever the modern phrase is, so it might be worth millions. But what is the court to do at the interim stage? What if the individual has a private income from other sources? Does one take that into account in considering whether or not it is valid? The other difficulties are difficulties which this court, we would respectfully say, has identified. My Lord Kerr said, well, can it be right that a covenant in restraint of trade falls in and out of that doctrine just because of individual circumstances? The answer is, of course not. And are we at every interim hearing, when one would ordinarily be asking the question, is this clause justified? The judge is to sit down and say, well, the first question I have to ask myself in respect of this employee's restrictive covenant is, does the restraint of trade doctrine apply? That's just adding another level of confusion, if and to the extent that at first instance decisions are confused at all. That's adding another level, completely unnecessary in the context of this sort of contract. How, again, just to adopt a point that was made, I think, this morning, how does the court test whether there's a background in entrepreneurship, which means that you would say, oh, well, this employee was quite keen on setting up a business, and so we infer that she would have wanted to set up a business, but this other employee may not have been keen on setting up a business, so we are going to take a different approach to her covenant. All of these suggestions are completely unworkable. And that's why one doesn't see any sign of them in the authorities. The approach that has been taken, the orthodox approach that has worked for over 100 years, is to say, in relation to post-termination restraints in employment contracts, restraint of trade applies. Now, once it applies, the question is, can it be justified? But again, that does not place a heavy burden on the shoulders of the employer. If it can be justified, that's fine. The court enforces. If it cannot be justified, the court does not enforce. My lady, I'm very conscious that the court kindly agreed to sit until 4:15. I wonder if that's an appropriate point to stop.
Exactly correct, according to the clock I use here. Thank you. Well, the court will now adjourn and look forward to hearing from you further at 10:30 tomorrow morning.